This is KTN News.
A very good Sunday morning to you from the KTN News Center. It is the third day of September 2017, and of course we are here to discuss some of the big stories of the week. There is only one very big story, and after 14 days of some grueling battles, that is court battles in the highest courtroom in the land, among some of the best legal minds in the Republic, finally the Supreme Court made its ruling on Friday, becoming only the fourth country in the world, the only country in Africa to nullify a presidential election, that is invalidating the election of President Uhuru Kenyatta. And that, of course, has been followed by lots and lots of reactions from both sides of the political divide. That's what we're going to discuss for the next 2 hours or so, discussing the Supreme Court ruling, some of the behind the scenes that led up to the run-up to that decision by the Supreme Court, the intrigues, 4 judges against 2, that is, of course, the 6-judge bench with Supreme Court Judge Mohammed Ibrahim indisposed. We'll talk about what next for the Independent Electoral and Boundaries Commission, who have less than 60 days to prepare a fresh presidential election. The NASA side is already calling for IEBC to be disbanded. And of course, is there enough time to do that and hold a fresh election? One of the losing presidential candidates calling for the United Nations to carry out the election. A lot being said. We'll talk about that. Also, what next for the political side? That is Uhuru Kenyatta and Raila Odinga. NASA and Jubilee already back on the campaign trail. We'll talk about all that. Many thanks for joining me on this edition of Kivumbi 2017, our continuing post-election, post-Supreme Court ruling analysis of the political situation in the country. Let's start with that big decision, or that big announcement by the Supreme Court President, Chief Justice David Maraga.
The decision of the court is that the first respondent failed, neglected, or refused to conduct the presidential election in a manner consistent with the dictates of the Constitution, and inter alia, the Elections Act, Chapter 7 of the laws of Kenya. Number 2, as to whether there were irregularities and illegalities committed in the conduct of the 2017 presidential elections, a declaration is hereby issued that the presidential election held on 8th August 2017 was not conducted in accordance with the Constitution and the applicable law, rendering the declared results invalid, null, and void.
A monumental announcement by the Chief Justice David Maraga that has had reactions from all corners of the Republic as well as on the continent, invalidating the election, the presidential election, the election of President Uhuru Kenyatta for a second term, making or putting Kenya in course for another presidential election within 60 days. My guests are here with me to help put some perspective on this morning. I have with me Dismas Mokua, political risk analyst. Not very new on the show, of course. He has been, I think, the most consistent member of this panel. And I have with me somebody who's been missing in action, but for good cause. That is Jared Okello, one of the founding panelists of this show, yes, who is now a member of the 12th Parliament. Karibu wana Mheshimiwa.
Thank you,
and congratulations from all of us.
Oh, well, thank you. It's always good to be back on KTN News TV studio.
Karibu sana. I also have political analyst Hesbono Wheeler and Jubilee strategist Mutinda Kavemba. Good morning, gentlemen. Good morning. Thank you so much for joining me this morning. The papers are describing this and pundits as a shock decision. Everybody, or most people, expected the Supreme Court to uphold or not to invalidate the election of President Uhuru Kenyatta. Dismas, what was your initial reaction to this?
Actually, one wonders why anybody would want to say that it's a shock, because when you go to any court, there are two decisions. I mean, there are only two probabilities. It will be in your favor or in the favor of the other party. So really, I do not see any shock. The shock is in the reaction of the two parties, the main parties, and we go back to 2013. And in 2013, we were prepared that when the Supreme Court makes a ruling, you should live with the ruling. You should accept and move on.
Right.
But at this time round, it seems like Jubilee is unhappy with the outcome, and they've started casting aspersions on the integrity of the judiciary, and especially the Supreme Court. And it's important to go back to the Constitution, that the powers of the presidency are drawn from the Constitution. That's Article 131. And the powers of the Supreme Court are also drawn from the Constitution, Article 163. So the presidency draws the power from the Constitution via the Kenyan people as well as the Supreme Court. So when the Supreme Court takes a decision, it's erroneous for us to look at the individuals, the personalities, and then you start saying that Justice Maraga has taken a decision. It's a corporate decision drawn from the people. And again, there's an erroneous perception that the judges are acting on their own motion, that they do not represent the cumulative interest and aspirations of the entire nation. You cannot wake up this morning and walk to the Supreme Court and say that I want to be a judge. You must have the necessary experience. When there's a vacancy, you must apply. And then if you go through the Judicial Service Commission, your name is taken to the relevant parliamentary committee where you undergo vetting. And then eventually, the entire House forms a view. So when the entire House forms a view that you are qualified to be a judge of the Supreme Court, indirectly it's Wanjiku who's given you authority to enforce the Constitution. And that's one of the mandates of the Supreme Court. Yeah.
All right.
So it's erroneous for anybody to start saying that those 6 people using derogatory terms, or those 4 people have usurped the will of the entire nation. No. I mean, like for instance, when he's a party leader, and I'm sure he's very proud, Mheshimiwa Okello, when there was a bit of reluctance that he was not willing to go to the Supreme Court, all and sundry, including the international community, said to Mr. Raila Odinga, don't go to the streets, go to the Supreme Court. So essentially followed the advice of the international community, as well as President Kenyatta. He went to the Supreme Court. And when an outcome has come from the Supreme Court which is not favorable, then again he casts aspersion on the integrity of those very persons. And when he said that he disagrees but accepts the outcome, that is supposed to be the best practice. You remember Al Gore, when he was told that you are not going to be president of the U.S. by the Supreme Court. Right. He said, well, I disagree. I respect the decision. And he did not go ahead to start attacking the individual personalities. When you look at Justice Maraga, Philomena Mwilu, Lenaola, and smoking, and start attacking the personalities, right, then it's unacceptable in the context of our democracy. It's something
many people are calling an attack on the judiciary. We'll get into that very shortly. Jared, did you expect this?
Well, at the very outset, Ben, allow me to express my empathies to the parents and school fraternity of Moi Girls High School, Nairobi, for losing such young souls. As a nation, we are united in grief, and we pray that God will grant them a very quick healing. But most importantly, to note that other schools have also experienced such inferno in the last 24 hours.
Right.
So we hope that this will be quickly investigated, and if it is man-made, let the culprits be brought into book. I wouldn't wish to be the devil's advocate, but if somebody is doing this in order to dissuade the thinking of the Kenyan people on the most important issue of the court ruling, then we will pray for them, that God grants them mercies. Well, I think really for us in NASA Coalition, we expected this. Lawyers will tell you that cases are won based on the evidence and submissions before the judges. In the year 2013, when we firstly went before the Supreme Court, even though we still had cogent evidence to disturb the election of Uhuru Kenyatta, the courts further refused to admit part of our evidence. And you saw what happened during this proceeding, the just concluded proceedings. Maraga tried as much as he could, Honorable Justice Maraga, tried as much as he could to accommodate all parties. And in light of Article 159 of the Constitution, that says justice must be delivered without due regard to procedural technicalities. So he shoved by the wayside any available technicality that could hinder a justice to be delivered to the Kenyan people. Because this was not about Raila Odinga, as some section of the political divide would want us to believe. When a nation goes into an election and the wishes of the Kenyan people are not expressed in the outcome, then that is something that has to be interrogated. So Maraga, together with his team, tried as much as they could to incorporate every litigant who had an issue to express before them. And even when my friend, lawyer Kanjama, was disappointed by lack of admission, it was a well-reasoned decision that firstly, he's a member of Law Society of Kenya, and secondly, he's the chairman of the Nairobi branch of the LSK, and LSK had already been given a mandate to be heard within that court. So that was a very well-reasoned decision. All parties were given adequate time, top lawyers in the nation, but, we still won and they still lost, based on the evidence that was before them. When a party is meant to provide a rebuttal, you have to provide a counter evidence. It is not just hearsay. So when Jubilee wing of the litigation couldn't provide sufficient evidence to tinker with the decision of the court, they were bound to lose. But most importantly, when IEBC, a body that is mandated by law to conduct election, is given an order by a court of law, forget about the Supreme Court, to the very least talk of a magistrate's court. When a magistrate, even though in the court hierarchy, sits to the lowest ebb, gives out an order that has to be respected. But here comes the Supreme Court, the apex court, the top court in the world, sending you to go and bring evidence, and you just refuse to abide by. That was bound to, they were bound to be, found culpable of very serious transgressions. And we hope that at this point in time, they are now going to open the servers, tell us what is contained in the servers, lest we file before the court contempt. And contempt has very grave consequences. So let us give them time, open the server, and if Raila won, because I know that is what is espoused in the servers.
So you're still going to pursue that?
We have to. I mean, it is a matter of respect for the rule of law.
All right.
And Justice Maraga did indicate as such.
All right.
If a nation is not going to abide by the laws that it has set by itself, then that is anarchy. For a country such as Kenya, we don't want to get there.
Mutinda, when you spoke last week here on the show, you were very confident of delivering a win because you believed NASA did not have a case, or the petitioner did not have a case. What do you think now?
Now, this must say that there was nothing shocking with this ruling, but the truth of the matter is that that there was something very shocking. And I'll use the probability rule to explain why that was shocking. That that has never happened in the entire Africa, and that in the entire world, it has only happened in 3 places, the Maldives, the Ukraine, and Austria. So then why was it not a shock for it to happen here for the first time and the 4th time in the world? So just by the probability rule, then it's clear that that was not what was expected. But having said that, you see, at the end of the day, there is the issue of the sovereign will of the people, and elections are mostly about that. It is the only opportunity probably that we get a chance as the citizens to directly exercise our sovereignty. And on the basis of that, we were saying that probably we were not expecting the Supreme Court to do that, because from what we had heard in court, we had not seen any evidence that showed that whatever errors or irregularities that might have occurred were substantive enough to have affected the overall outcome. I'm very keen waiting for the detailed judgment, so that probably there is what the court got to know, and the CJ himself admitted that they have not had, and apologized, had the opportunity to give a detailed ruling, but they'll give it. So some of us are very keen to see what is it that they exactly established that probably led them to that route.
Right.
But having said that, I think Kenya is a democracy, and accountability is to everyone. And the judiciary also should be ready to be scrutinized when certain Kenyans feel that there is need. The most important thing is that the law is very clear on how to go about doing this stuff. And as much as Jubilee feels aggrieved and have been expressing their opinions about how aggrieved they feel, they've respected the ruling, and they've already hit the ground looking for votes, simply that proving that they are in compliance. So I don't think it is right to demonize Jubilee people for expressing their dissatisfaction and the disapproval of what happened. Because the truth of the matter is this: the others celebrating. They are expressing their joy and satisfaction with what happened. What would be wrong with the others who are not satisfied also expressing the same? In any case, I've not seen any road blocked. I've not seen any law broken. But people are hurting. You know, probably a very big chunk of this country is hurting.
Some Kenyans are saying that the terms used, we'll get into that in
and yeah, it looks like there is an effort to gag some people. What I'm trying to say is that call like seems to be gagging others from expressing their dissatisfaction is also not fair. Let those who are not feeling right express it. The most important thing is, if there are issues, you see, if the 6th judge bench, if they themselves differed, if 2 of them were of an alternative view, why then would we be demonized for also expressing our different opinions about that? I think let Kenyans understand what democracy is all about.
Right.
As much as those who are celebrating are justified,
this one is disagreeing.
Those also who are aggrieved are also within their rights to show their dissatisfaction.
Ben,
very quickly,
Ben, the President of the Republic of Kenya is not your normal pedestrian villager in Kisii or where he comes from in Nyando. Any word which comes from President Kenyatta's mouth is so powerful. That's why he has to be structured. When you're addressing your supporters at Bama, then you say that the Supreme Court is composed of Wakoras. What are you communicating to the nation? What are you communicating to the world? That's number one. Number two.
But he's also a party. He was a party in that.
I previously have heard the NASA leader say Mahakama Bandia. You know, let's be very fair on each other.
We're talking about
severally had him call Mahakama Bandia when it gave rulings that were not in conformity with what he expected.
The President of the Republic of Kenya.
Their opinions and dissatisfaction.
All right, Hesbon, yes.
I think in a democracy, whatever Kavemba is saying is actually true, that you are free to express yourself. And there's a thin line between expressing yourself and an affront on other parties. And I think Jubilee is walking that line. It is becoming less clear whether it is expression of their dissatisfaction or an affront on the judiciary, and specifically the Supreme Court, which is very unfortunate. You know, they need to be very clear on which line they're walking. And then secondly, you look at this ruling, and if you didn't see this coming, then probably you didn't understand the electoral process from the beginning. Because some of these things, we actually understood them from how IEBC espoused them, the electoral process, and it is enshrined in the law. And I think at some point we made it clear that it is easy for NASA to present, you know, a petition and the respondent to say that it is an easy thing, we can easily deal with it. But you remember, when you present a petition, you have evidence, and it is for the respondent to come up with a rebuttal. And we talked about evidential burden, and to the extent that that is required in the determination of any case, you realize that Jubilee, IEBC, and the IEBC chair terribly failed to provide that. And I think we'll see that in the comprehensive ruling. But then coming back to the ruling, I mean, it is technically not about the Jubilee side of the divide or the NASA side of the divide. It is basically about the people of this country and the jurisprudence and how it is going to expand our democracy. And it is important that we look at Justice Maraga as this monument, you know. Actually, I would say a very tall monument of justice who is anchored in the rule of law and the love of God, because that is what came out. And again, to come back to the whole issue of the reaction, you realize that in everything that happened, there are guys who felt disappointed. There are sections of this country that was celebrating. And of course, there are Kenyans who are indifferent. They didn't care about the ruling anyway. But then, the silent realization that we get from all these three categories of Kenyans is that they realize that justice equals peace. And that is the extent to which you realize that everyone now is waiting. And it is unfortunate that now we're having this debate about the ruling, yet in the beginning, that is what all Kenyans were yearning for. I mean, the entire country was actually waiting for Raila to go to the Supreme Court. The international community was asking Raila to go to the Supreme Court. The Jubilee side of the political divide, led by the president and the deputy president, asked him to go to the Supreme Court. So it is only prudent that now we have a determination. They go back. And you see, if Jubilee, you know, the way NASA won this had nothing to do with the numbers. And actually, IEBC made it clear that the third respondent is not culpable in anything. And therefore, the submissions that were made by their defense was very clear that they had the numbers. No one has a problem with the numbers. So if they think that they got those numbers and IEBC was responsible for the illegalities and irregularities that denied them their hard-won victory, then it should not be difficult for them to go back, get those numbers, and actually question this IEBC that made them lose an election.
Right, good points. On page 5 of the Sunday Standard, talking about intrigues that you know, in the lead up, in the run up to Friday morning, when CJ Maraga did make that announcement. Let's talk about you know, how the bench made the decision. Of course, it was a 6-judge bench with the Justice Mohammed Ibrahim indisposed. 4 judges for the decision to invalidate the election, and 2 judges with a dissenting view. Of course, the 4 including CJ Maraga, Deputy CJ Philomena Mwilu, Justice Isaac Lenaola, and Smokin Wanjala, with Njoki Ndung'u, and Justice Professor Jackson Ojwang also having a dissenting view. At some point, we were told it was a 3-3 tie. There was some lobbying. I don't know what you've heard this month, but what is your analysis of how the judges voted for this case, in this case?
Well, maybe before we go to voting, let's look at the key aspects of the Supreme Court. They gave an order for IEBC to open their servers and give some critical information. Now, one wonders, if IEBC conducted free, fair, and credible election, where were they embarrassed to open up? Why were they embarrassed to give us all the necessary information? That should disturb anybody in Kenya. And then, what would give IEBC commissioners, or some commissioners at IEBC, and managers, the guts, the confidence to disobey a Supreme Court order? You know, those are the questions that one really needs to start asking themselves loudly, because unless there's so powerful cartels controlling IEBC, that are probably the cartels that told them, you guys go ahead and obey the Supreme Court, and you are covered and you are safe. And it would be very surprising if the Supreme Court does not cite a number of commissioners and officers at IEBC for contempt of courts. But when you go back to the ruling, and you remember we had this discussion some time ago, maybe this is the time to blow our own trumpet here. We said the ruling is going to be anchored on 2 aspects. There's going to be the qualitative aspect of it, whether everything was followed according to the Constitution, according to the enabling statutes, or they were just going to look at the figures, which was going to be pure quantitative. They're looking at 50% plus 1. And you recall we also said that for Justice Maraga, as a judge of the High Court and Court of Appeal, he's done so many petitions. And wherever he's made a ruling, anybody who has had an opportunity to appeal is appealing because they want to buy time. It's not because of any fault. And anybody who would study those judgments or rulings would have prepared on the qualitative aspect. And we kept talking about this for times above number. And I suspect that's what they looked at. You recall at some stage Smokin Wanjala asking the IEBC lawyers, as well as Jubilee lawyers, that when you go to a polling station, you are given 6 ballots. You decide to vote only for the president. What happens to the other 5 ballots? And at that stage, you saw the 2 lawyers representing President Kenyatta and representing IEBC were mumbling away because they were not prepared to discuss the process. And Justice Maraga was very clear that this election is not a one-day event. It's the entire process. When you go through Lenaola's rulings and his philosophy on election petitions, it was not hard to come to the conclusion that they were going to look at the qualitative aspects. And that's why I said, for me, this was not a surprise. Because when you go to court, you're prepared for those 2 options. And when you look at the evidence presented by NASA, they went the extra mile to try and convince the court that quality was not observed. One of the key submissions, which was very interesting, was by the Attorney General, who said that when you're going to determine this matter, forget the constitution. Look at the enabling statutes. And you recall Justice Maraga said this thing was not done in a manner that respects the constitution. So when you put those in the cumulative aspects, then one would understand why this ruling was done. And for Kavemba, if President Kenyatta won this election in a manner which was free, fair and credible, they must not be worried about this ruling, because they've got the opportunity within 60 days to go back to the same voters and tell them that our vote was won. So Jubilee must not be worried if they won in a fair manner.
All right.
They'll go back and they'll do the same.
He's worried? Because he's already hit the ground campaigning. It's very clear we are going back to the election. And people should come out and reaffirm whatever they did on the 8th.
All right.
So what makes you feel
we'll get
like
into the politics. We'll get into the politics and the
I'm
campaign.
just responding to the bit of worried.
Right.
What makes you feel like Jubilee is worried?
But allow me to...
Right.
Allow me to
We are
say
just
my last-
expressing our dissatisfaction.
We'll get into
but we've already
Jared.
agreed with the ruling.
Jared, Chief Justice David Maraga, his deputy Philomena Mwilu, and Justice Isaac Lenaola are 3 of the 4 judges who voted for that decision to invalidate the election are all new members of the Supreme Court, as was constituted in 2013. How do you see this decision impacting on the perception of the Supreme Court as it is right now? It was demonized so much in 2013.
Well, the biggest task the Supreme Court had was to reclaim its integrity. We have had authorities, particularly the 2013 authority that emanated from the Supreme Court, that cannot be quoted anywhere in the world. Even with failed states cannot use that authority to apply on their own judgments. It was the worst judgment ever in the creation of the world. That is fundamental. So
was it because it did not favor the court petition?
No, it was not reasoned. It wasn't reasoned. If a reasoned judgment, and people have gone to court and lost litigations, but when you lose fairly, you carry up your hand in surrender. And people who are languishing in jails, some of whom committed heinous crimes, are there and are very comfortable that they got justice by being in jail. But here is somebody subjecting you to an injustice, but still expect you to accept, move on, and let life continue. We did accept to move on, but we rejected in its entirety. The same thing Uhuru Kenyatta is doing, even with a well-reasoned judgment. Well, the gist of that decision will be coming in 21 days. But, authorities are abound about what is the threshold of disturbing an electoral process. It has been said enough times, more than number, that it has to be above preponderance of doubt, but not beyond reasonable doubt. So it is somewhere in between. But what NASA did present in court was actually beyond any reasonable doubt. Even if a criminal justice system was to be applied, then the kind of evidence would put Chiloba and company in jail forever. Because we attained, and for criminal proceedings, it has to be beyond a reasonable doubt. And we proved that. My constituency, for instance, where Raila got, Honorable Raila Odinga got over 60,000 votes. According to IEBC, he got 0. Personally, I got 61,000 votes, 301. On the other hand, Raila gets 0 from Nyando constituency, and IEBC would want the country to believe that indeed Raila got 0 from Nyando. A very simple question was thrown to them. 577,000 voters primarily voted for just the president and went back home. That was possible, and the reasoning that were given could have convinced the nation. But here was the blunder. They said that the diaspora votes only voted specifically for the president. Those who were in prison only specifically voted for the president. But how many are they? There were 4,000 in jail, 5,000 in the diaspora. So that is 9,000. So give and take, 468,000. Why would somebody walk into a polling station, a polling booth, with 6 ballot documents in hand, but only take the president? And the second question that was thrown to them, that they are still pondering to date, how do you call the ballot papers that were not attended to? Because they are not stray ballot papers. Today, Jubilee, together with their lawyers, haven't had that answer to this very day. But still, they expected to win that case. If 468,000 votes were at stake against a win of 1.4 million, and remember, Uhuru Kenyatta, according to IEBC, got 53% of the votes cast. 1.4 million over and above Raila Odinga. So that definitely brings it down, if you have to remove 468,000 votes, to about 47,000. What does the Constitution say? You must have 50% plus one human being who voted. They couldn't, convince us with that. But they are still out there, with flags about the conduct of the Supreme Court. So many talking
points of this decision. Mutinda, from where you sit, where do you
I haven't answered your question. 3 new judges came into court and have chosen to go alongside the constitutional requirement. Three judges. And they came into court knowing perfectly well that the confidence of Kenyans as far as Supreme Court was concerned was at stake. So they had to firstly reconcile that particular reality. So what did they do? They chose the path of the truth. Definitely Maraga did express himself during the interviews and said, firstly, I will never accept a bribe, and I have never accepted a bribe. For me, that was a harsh indictment on the conduct of the court. So it was like reading a riot's act to fellow judges to just do the right thing, follow the law, respect the God who created the universe, and let's do things that will inspire confidence in the Kenyan people. So then you had Wanjala, who was there in the previous court. What did he do this time? He chose to interpret the law as it ought to be.
All right. Mutinda, very quickly, the same question on the composition of the courts and how that influenced that decision.
I really have no issue with the composition of the court, because I think what should be discussed is what you've said about the more than 3 members who are new and who probably felt very different from what the other Supreme Court did with the previous election petition. That probably came out clearly because all the 3 of them voted differently from what happened last time. But I think the difference in this was that there are those who looked at the qualitative aspects, and I think the 4 actually looked at that. They were very strict to the provisions of the Constitution, and that they were not as focused on whether whatever happened had an impact on the overall result like the 2. Because if you listened to the 2 that were dissenting, they were of the opinion that for as long as whatever has been produced as evidence does not meet the threshold of having interfered with what the people were trying to say in that election, then they didn't see why it should have been nullified. I think that was the difference. There are those who stuck to, do we really have evidence that there was interference with the will of the people, or is it just about the technicalities of the wrong forms used, about things that could probably prove that constitutional principles were not, but could not put tangible evidence on manipulation of figures, unlike what he has said, because I'm waiting for that report. That's why I'm waiting for that judgment to look at some of the incidences like Mheshimiwa has given of Nyando. Then of course it would be quite unfortunate if some of those incidences where someone got 60,000 and 0 is indicated were there, and that's why we have to wait for this well-reasoned and detailed judgment so that we really know on what basis they took that decision that was a shock to the world. As much as this much doesn't want to look at it.
All right.
I hate to interject.
Let's take a short break. We'll come back with more of that. When we return, we'll talk about more of these talking points from that Supreme Court decision on Friday. And most importantly, we'll talk about what next moving forward. What next for the Independent Electoral and Boundaries Commission, a discredited electoral commission set to organize another fresh presidential election within 60 days. We'll also talk about the reactions, especially the utterances made by the President Uhuru Kenyatta and his deputy William Ruto and the Jubilee contingent as they expressed their dissatisfaction with the Supreme Court ruling. Some pundits or Kenyans saying the President is bordering on insults or threats to an